Today I want to take you through some of the peculiarities that can be thrown up when a treaty has deviant clauses on remittance, for instance, or anti-abuse clauses. And in this particular case, we'll look at two cases from the Dutch Supreme Court on company transfers from Holland to Malta and on how the Dutch Supreme Court interpreted the treaty in this regard. The cases concern companies that moved their corporate tax residence from the Netherlands to Malta. What you see in the background is some pictures from Malta itself. So if we look at Article 4 of the Dutch Maltese Treaty, it is the pre-BEPS version for companies which says where a person other than an individual is a resident of both states, it shall be deemed to be a resident of the state in which its place of effective management is situated. So we're applying a POEM test, right? POEM. And then Article 23 says items of income of a resident of one of the states, wherever arising, not dealt with in the foregoing articles of this agreement, shall be taxable only in that state, and paragraph 2 has a normal PE clause. Now there is a fascinating part of Article 21 that people do not always realize, and that is that it does not only apply to weird types of income like firing someone and hurting their professional profile or something like that, but it also applies to dual resident taxpayers. So let's have a look at the commentary, the OECD commentary to the OECD Article 21. It says, the scope of the article is not confined to income arising in a contracting state. It also extends to income from third states. For instance, a person who would be a resident of two contracting states is deemed to be a resident only of one of these states pursuant to the provisions of Article 2 or 3 of that article, of Article 4, right? This article will prevent the other state from taxing the person on income arising in third states, even if the person is resident of this other state for domestic law purposes. So if a company is resident in Holland and in Malta, and under Article 4 is only resident in Malta, then normally only Malta can tax the income, even if that income, for instance, comes from Switzerland. Yeah, and then just to underline this, paragraph 3 of the commentary says the rule set out in the paragraph applies irrespective of whether the right to tax is in fact exercised by the state of residence. So if Malta doesn't tax, it normally doesn't mean that Holland can tax. Yeah, it goes on to say, likewise, when income arises in a third state and the recipient of this income is considered as a resident by both contracting states, the application of Article 4 will result in the recipient being treated as a resident of one contracting state only. In this case, the other contracting state may not impose tax on the income arising from the third state, even if the recipient is not taxed by the state of which it is considered a resident under Article 4. In order to avoid non-taxation, contracting states may agree to limit the scope of the article to income which is taxed in the contracting state. A 10-second commercial. If you want to learn more about international tax, transfer pricing, or Pillar 2, or you want your team to learn more about these, please visit our online courses. So let us look at Article 2, Paragraph 5 of the Dutch Maltese Treaty, which deals specifically with remittance, because Malta has rules saying if you've got foreign income and you do not bring it to Malta and you're a foreign shareholder, we will not tax you as long as you do not bring that income to Malta. At least they had the rule at the time, and Article 2.5 excluded that rule, that income from treaty protection. It said, where under any provision of this agreement income is relieved from tax in one of the states and a person is subject to tax by reference to the amount thereof which is remitted to or received in that other state, then the relief to be allowed shall apply to so much of the income as is remitted. What you don't remit does not get double tax relief. And then Article 3.2 of the treaty is the normal catch-all interpretation of treaty terms where it says, as regards the application of this agreement by either of the states, any term not otherwise defined shall, unless the context otherwise requires, have the meaning which it has under the laws of that state relating to the taxes which are the subject of this agreement. So if Holland were to apply this treaty with regard to whether something has been remitted or not, and remittance is not defined in a treaty, then the Dutch tax definition, or otherwise normal definition of remittance, would need to be applied. And now we come to an interesting article, Article 30, the exclusion of certain companies or other persons, where paragraph 1 says this agreement is not applicable to companies or other persons which are wholly or partly exempted from tax by a special regime under the laws of either of one of the states. It is also not applicable to income from such companies nor to shares in such companies. And then it says, paragraph 2, the provision of paragraph 1 of this article are also applicable in case a company or other person is treated under administrative practice in the same or similar way. So it's not only the law and special regimes which can kick you out of the treaty, it is also administrative practices that can kick you out of the treaty if they are somehow wholly or partly exempting you from taxation. And then paragraph 3 is important. The competent authorities of the state shall by mutual agreement decide which special regime is meant in the provisions of paragraph 1. So you cannot just, as Holland, say, you know what, we throw out this if you haven't agreed with Malta up front that this is a regime which is covered by Article 30. And then there is a provision that looks to the future, and it says the provisions of paragraph 1 are also applicable to any identical legislation enacted after 1 January 1993 unless the competent authorities of the state decide otherwise. And I think 1 January 1993 must have been when they started negotiating the treaty, the protocol to this treaty which introduced Article 30, and that protocol got enacted in 1995. And then finally Article 25.4 addresses Article 30, where it says, when we deal with the elimination of double taxation, notwithstanding the provisions of paragraph 2, which is your normal double tax relief, the Netherlands shall allow a deduction from the tax computed in accordance with the preceding paragraphs with respect to income that may be taxed in Malta according to Article 7, if such income is subject in Malta to a special regime as meant in Article 30, because now Holland can tax it because the treaty doesn't apply, right? The amount of this deduction shall be the lesser of, and then you get your first and second limitation, the amount equal to the tax in Malta, and the amount of the Netherlands tax which bears the same proportion to the amount of tax computed in conformity with paragraph 1. So our conclusions so far are, normally under Article 4 and 21, only Malta can tax third country income. Holland cannot tax just because Malta does not. 2. Article 2.5 sets Article 4 and 21 aside as far as income is not remitted to Malta. But if it is remitted, Holland cannot tax even if Malta does not. And then 3. Article 30, paragraph 1 excludes companies which are exempt by a special regime whether the income is remitted or not. And then under Article 33, the competent authorities must decide by mutual agreement procedure what a special regime is. Now, remember I told you that the competent authorities have to agree on what a special regime was, and what you see here is the exchange of notes between the two competent authorities when the treaty entered into force. And you can see here on the 18th of July 1995, the Maltese government representative wrote, "I have the honor to state on behalf of the government of Malta the following. The Malta International Business Activities Act 1988, the MIBA Act, is considered to be a special regime as meant in the provisions of paragraph 1 of Article 30. However, the provisions of paragraph 1 of Article 30 are not applicable to companies who are subject to tax on their total income to the full rate in accordance with the provisions of the Income Tax Act Cap 123, and who have waived irrevocably their rights to protection under Article 38 of the MIBA Act. So this was one of those special regimes targeted by the Netherlands and, for that matter, by the EU and the OECD. And Holland then responded on the same day, "Excellency, I have the honor to acknowledge the receipt of your letter of today's date. I have the honor to inform Your Excellency that the foregoing is acceptable to the government of the Kingdom of the Netherlands, and I have the honor to confirm on behalf of the government that your letter and this letter in reply shall constitute an agreement between the Kingdom of the Netherlands and Malta." And then, just for the sake of nerdiness, please note that this is an agreement, this is not a treaty. A protocol is a treaty. The exchange of notes on the interpretation or application of that protocol is not a treaty, it is just an agreement under international public law. So let us briefly look at these two decisions from the Dutch Supreme Court. The first one is from 17 October 2025, and the facts can be briefly summarized as follows from the Advocate General summary itself. The taxpayer, we'll call it XBV, is incorporated under Dutch law. On 1 December 2011, its registered office was transferred to Malta from the Netherlands. During 2012 to 14, its actual management was conducted in Malta, so it was clear it was a tax resident of Malta, right? Since 30 December 2011, all its shares were held by a Belgian limited partnership, a CV, in which A held 99.99% and another held 0.1%. Now, this Belgian CV was most likely tax transparent for Belgian tax purposes and for treaty purposes, and for Maltese purposes. So whatever happened between XBV and A were allocated to A directly. It was not stuck from a tax point of view in the Belgian CV. A emigrated to France on 1 January 2012. For 2012 to 14, XBV applied the exemption under Article 15E of the Corporate Income Tax Act, so I assume that's as foreign income, to 200,000, 1 million and 500,000 euros in Swiss capital gains on securities and or German trading profits respectively. What happened here is this company ran its business during the lifetime of A. It made a lot of profit. It only had cash left. It invested that cash, and the guy didn't want to pay tax, or the woman didn't want to pay tax on that in the Netherlands, and implemented this Maltese Dutch Swiss structure. The German trading profits, incidentally, was profits made from selling sandbags. There was a huge floods in Germany in, I can't remember whether this was 2012 or 13, and somehow XBV got hold of a huge number of sandbags, which they then sold to the German government to deal with some of this disaster control, I assume. And then 1.4, XBV is a non-domiciled resident in Malta. So remember, there's a difference between domicile and residence. If you are a resident but not domiciled in many English systems, like you also had in the UK for the non-dom taxpayers, you only pay tax on the money you brought home, right? Not any of the money or the income that you left offshore. And this is what was happening to XBV. It was non-domiciled, so it wasn't paying tax on the money he didn't bring home. For 2012 to 14, he declared foreign income in Malta that was not remitted to Malta. For 2013, XBV declared 1,007,000, almost 8,000 in German trading profits. This was these sandbags as foreign income, and declared a dividend of 1,008,000. So it had a couple of €100 lying around. The net dividend after 352,000 of Maltese tax and costs was distributed to CBV, to CV, and that was actually the BV, right? Because the CV was tax transparent, which utilized a Maltese refund scheme under which the CV/the BV received a refund of 302,000 out of the 352,000 in December 2015. So ultimately, the company earned 1 million, it paid 50,000 in tax. Yeah. The inspector imposed the corporate income tax assessments 2012 through 14 without any exemption, and then just again the summary here. Out of 1,008,000 euros, the company ended up paying 50,000, which is 5% tax in Malta only, while the normal tax regime for someone resident in Malta in these situations would have been, I believe, between 30 and 38%. And then there was a second case which was decided on 21 November 2025. And this case for international tax law is slightly less interesting because the decision was largely dependent on what the Supreme Court was going to say in the 17 October case. And that was more or less just copied and pasted into the 21 November case. The 21 November case, also if you look at the Advocate General opinion, revolved much more around legitimate expectations, around whether the tax authorities were entitled to make an assessment, whether it was the right tax authority within the Netherlands had made the assessment, etc., etc., etc. Not so interesting from an international tax point of view, but I do want to show you this case because there is some interesting subtexts around this case which talks about why there are so many of these Maltese Dutch emigration cases. So just very quickly, the facts here. 2.1, the taxpayer YBV is a Dutch BV. Its activities from 2012 to 14 consisted of providing loans and holding investments. Same thing, rich guy stops his business, emigrated, invested income, didn't want to pay tax on the income from that investment in the Netherlands. Until 20 November 2014, the shares in YBV were held by a natural person who moved from the Netherlands to Switzerland in 2002 already. Since 2004, YBV had a permanent establishment in Switzerland. On 18 November 2011, YBV transferred its effective management to Malta because of a new Dutch-Swiss tax treaty. And I don't know whether that had an anti-abuse clause or not, but in any case, the taxpayer told the tax inspector they moved because of the new treaty. There was something in there they didn't like. Talk about treaty shopping, right? 219 then, I leave all the rest out in this decision, but this is coming from the Advocate General's opinion. On 9 May 2018, the Dutch tax inspector wrote that YBV uses the remittance-based regime in Malta, whereby only remitted foreign income and income received in Malta are taxed in Malta. And what happened until this time was that the company, because it was incorporated in Holland, had to file a zero tax return every year, which the tax authorities followed. But that's because they didn't know that this company was making use of the remittance regime. And all of this came out in a larger coordinated exercise from the Dutch tax authorities. And then they said, sorry, but we're going to do additional assessments on all the ones that we've given you already because we didn't know that. And that's part of the technicalities of the Dutch law that was figured out and that were featured much larger in this case. So YBV's Maltese tax returns showed that it did not remit any income to Malta or receive any income in Malta. As YBV paid no tax in Malta in 2012 to 14, the Netherlands does not grant any tax relief, is what the tax inspector said. Based on the above, the tax inspector said YBV is liable to tax in the Netherlands on its worldwide income. So this case then followed the conclusion of XBV regarding international tax law and the Dutch Maltese Treaty and Article 30 and Article 2.5. So what came to light in the second case that makes this so interesting? Now, first of all, in 27 February 2015, the Dutch Supreme Court already ruled in another Maltese-Dutch immigration case, and it did so in favor of the Dutch tax authorities. And then there was an internal Dutch tax authorities document submitted to the court entitled Project Plan for Reallocated Dutch Private Limited Companies to Malta. And this report is interesting. It states, among others, the 2015, this is the internal document for the Dutch tax authorities, right? The 2015 Malta judgment thus surprisingly demonstrate that unmitigated pessimism is no longer justified and that a number of tax obstacles appear to be less problematic than they previously seemed. If one add to this the state-of-the-art case law, particularly regarding tax residence, there were also some cases where they won, but they said that these companies never emigrated to Malta, they were still resident in Holland, then relatively substantial opportunities arise. And what I love about this is, we're all just trying to do our jobs well. And here are the Dutch tax authorities hating the Maltese structures, finally finding that the courts are supporting them, and they are very, very excited about this, like any serious professional would be, right? They go on to say the Malta judgment specifically teaches that the tax treaty with Malta cannot be invoked pursuant to Article 30 if offshore regimes in force in Malta are used. The judgment appears to have broader applicability than just the offshore regimes at issue in the proceedings. Incidentally, the remittance-based provisions also appear to contain special, unsuspected opportunities for correction. And then following this, in between March and April 2016, so it took about a year to get this project going, 50 companies were sent questionnaires on their immigration, and another 19, including YBV, were investigated for also receiving questionnaires. And YBV did get one, and that led to the correction here. So what happened was they saw in 2015 that this case came out, they discussed it, they then set up a special knowledge group, and then the special knowledge group started running this project where they said, look, so let's look at all the companies that have emigrated between this and this period, and let's ask what's going on here to see if we can apply this 2015 Supreme Court decision and make some corrections to their taxable income. So let us look at what the High Court and the Supreme Court ultimately decided, and we're only going to look at the October decision because, as I said, that addresses the international tax aspects of these cases the clearest. First, the High Court held that Article 2.5 does not apply to capital gains received by a non-domiciled resident company because they are not taxable in Malta even when they are received in Malta, right? So that goes out. But then they said the High Court ruled that for the application of Article 30, paragraph 1, the effective tax rate for non-Maltese shareholders like these taxpayers is 5%, while for Maltese shareholders it is 38%. Clearly there's quite a difference here. And then 3, the High Court ruled that the ITA and the ITMA, so these were some successors of the original 1993 special regimes that we saw, favor companies established in Malta with non-Maltese shareholders to such an extent that those schemes are substantially similar to the Maltese International Business Activities Act, the MIBAA, that we saw before mentioned in this protocol in which they identified these special regimes. The High Court also held that any possible tax liability that a non-Maltese shareholder may face in the event of a possible redistribution of the dividend must be disregarded. So A said, you also need to remember that once the CV pays out the dividend to me, or the Maltese company pays the dividend to the CV, and then the CV pays it to me in France, I need to pay tax on that dividend in France. And the Dutch court just said, we don't care about that. We talk about whether this Dutch company, which now emigrated to Malta, is subject to a special regime, not whether you as a shareholder is subject to a special regime. It's a bit of a complicated discussion because remember, under Maltese law you only get this corporate income taxes that was paid by the Dutch company back once you pay out the dividend to the shareholder. Then the shareholder gets that money back. So there is a bit of convolution between the two, but I think the court made the right decision here. And then it says in point 5, the combination of the non-taxation of foreign source capital gains for non-domiciled resident companies and the absence of taxation when those gains are distributed results in 0 tax percentage rate, and that is obviously a special regime. And then under 6, Article 30 does not contravene EU law, and we're not going to dig into this, but the taxpayer tries to rely on some very old shareholder case law of the CJEU, arguing that this was not in line with EU law and the fundamental freedoms. I think the court threw that out correctly because there were later case law which made clear that it was not applicable here, incidentally involving Belgium. And then finally the Supreme Court agreed But all of the High Court's decisions and conclusions, it found them logical and reasonable and rejected XBV and by extension YBV's appeals against the High Court decisions. I hope you enjoyed this case. I think it's not every day that we get these exceptional treaty articles covered in case law, and it's always good to have a look at those as well. Bye for now.